82. The reading of the said returns concluded, the senators shall retire, and a committee appointed by the House of Representatives, and composed of one for each state, of those that have representatives present, shall revise them, and render an account of the result. SDCT 83. The House shall then proceed to class the elections, and enumerate the votes. 84. He who has an absolute majority of the votes of all the legislatures shall be the President. 85. If two should have said majority, he shall be President, who has the most votes, and the other the Vice President. In case of a tie with said majority, the House of Representatives shall elect one of the two for President, and the other shall be Vice President. 86. If no one should have the absolute majority of the votes of the legislatures, the House of Representatives shall elect the President and Vice President, choosing in each election one of the two who had the greatest number of suffrages. 87. When more than two individuals have a respective majority and equal number of votes, the House shall choose from them the President or Vice President, as the case may be. 88. If one has received the respective majority, and two or more have an equal number of suffrages, but greater than the others, the House shall elect from among those who have the greatest number of votes. 89. If all have an equal number of votes, the House shall elect from among them all the President and Vice President, doing the same when one has a number of suffrages, and the others an equal number. 90. If there should be a tie upon the voting of the classing of the elections made by the legislatures, the vote shall be repeated once, and if it should result in a tie, shall decide it by lot. 91. In the competitions between three or more that have an equal number of votes, the voting shall be directed to the reduction of the competitors to 2 or 1, in order that in the election he may contend with the other that may have obtained a relative majority over all the others. 92. For a general rule in voting relative to the election of President and Vice President, they shall not refer to lots before having made a second vote. 93. The voting on classifications of elections made by the legislatures, and on those made by the House of Representatives for President and Vice President, shall be made by states, the representation of each one having a single vote, and in order that there may be a decision in the House, it must contain an absolute majority of the votes. 94. In order to deliberate on the objects contained in the foregoing article, there must be united in the House more than the half of that total number of its members, and be present representatives from 3/4 of the states. Section 2nd. Duration of the office of President and Vice President. Manner of filling the vacancies of both, and their oath. 95. The President and Vice President of the Federation shall enter upon the discharge of their duties on the 1st of April, and shall be replaced precisely on the same day every 4 years by a new constitutional election. 96. If for any motive, the elections of President and Vice President are not made and published by the 1st of April, when they ought to take their seats, or those elected should not immediately enter upon the discharge of their duties, nevertheless, the former ones shall go out of office the same day, and the supreme executive power shall be deposited, provisionally, in a President, that shall be elected by the House of Representatives, voting by states. 97. In case the President should be indisposed, then the provisions in the preceding article shall have effect, and if both should be at the same time, and Congress not being in session, the supreme executive power shall be deposited in the hands of the Chief Justice of the Supreme Court, and 2 individuals that shall be elected by an absolute plurality of votes by the Council of Government. These are not to be members of the General Congress, and are to have the qualities requisite to be a President of the Federation. 98. Until the elections are made to which the preceding articles allude, the Chief Justice of the Supreme Court shall be charged with the supreme executive power. 99. In case of the perpetual inability of the President and Vice President to serve Congress, or in its recess, the Council of Government will respectively provide according to Articles 96 and 97, and so dispose that the legislatures proceed to the election of President and Vice President, according to the forms prescribed by the Constitution. 100. The elections of President and Vice President made by the legislatures in consequence of the perpetual inability of those to serve who had been elected for these offices shall not impede the ordinary elections the 1st of September every 4 years. 101. The President and Vice President newly elected must be on the 1st day of April in the place where the supreme powers of the Federation reside, and before both houses assembled, swear to observe the duties imposed on them under the following form. An elected President or Vice President of the United Mexican States, swear before God and the holy evangelists that I will exercise faithfully the charge the same U.S. have confided in me, and that I will keep and cause to be kept exactly. The Constitution and General Laws of the Federation. 102. If neither the President or Vice President present themselves to swear as the preceding article provides, and the sessions of Congress being open, they shall swear before the Council of Government as soon as each one presents himself. 103. If the Vice President takes the oath prescribed in Article 101 before the President, he shall enter immediately on the discharge of the duties of President until he shall have sworn. 104. The President and Vice President constitutionally appointed according to Article 99, and those individuals provisionally appointed to exercise the charge of President, according to Articles 96 and 97, shall be sworn as prescribed in Article 101, before both houses, if assembled; if not, before the Council of Government. Section 3 of the Prerogatives of the President and Vice President. 105. The President has the power to lay before Congress such propositions or amendments of laws as he may deem conducive of the general good, directing them to the House of Representatives. 106. The President has the power once in the space of 10 days, Sundays, and solemn festivals excepted, to make observations upon the laws and decrees passed to him by Congress, suspending their publication until the resolution of Congress, except in the cases mentioned in this Constitution. 107. The President, during the time of his administration, cannot be accused, except before either of the houses, and only in crimes alluded to in Article 38, committed in the time therein expressed. 108. Within 1 year from the day on which the President ceases his functions, he cannot be accused except before one of the houses for crimes alluded to in Article 38, or any others committed during the term of his administration. After this he cannot be accused for those crimes. 109. The Vice President, during the 4 years of his administration, cannot be accused except before the House of Representatives for whatever crime he commits during the time of his administration. Section 4. Attributions of the President and the restrictions of his faculties. 110. The attributions of the President are the following: first, to publish, circulate, and cause to be kept the laws and decrees of the General Congress; second, to give rules and decrees and orders for the better observance of the Constitution, Constitutional Act, and general laws; third, to put into execution the laws and decrees directed to preserve the integrity of the Federation and to sustain its independence in its exterior, together with its union and liberty in its interior; fourth, to name and remove freely secretaries of the departments; fifth, to direct the collection of and decree the inversion of general contributions agreeably to the laws; sixth, to name the officers of the Treasury Department and those of the Commissary Generals, diplomatic ministers, and consuls, colonels, and other superior officers of the permanent army, active militia, and navy, with the approbation of the Senate, and should it not be in session, with the Council of Government; seventh, to name all other officers of the permanent army, navy, and active militia, and officers of the Federation conformably to the laws; eighth, to appoint, after previous recommendation from the Supreme Court, judges and attorney generals of the circuit and district; ninth, to grant discharges and licenses, and regulate military pensions according to law; 10th, to dispose of the permanent armed forces by sea and land, and the active militia for the security of the interior and defense of the exterior of the Federation; 11th, to dispose of the local militia for the same purposes, but to take them out of their respective states or territories. It will require the previous consent of Congress, who will also designate the force necessary. Should Congress not be assembled, the consent of the Council of Government will be necessary, and who will also designate the number. 12th, to declare war in the name of the United Mexican States, after a previous decree of Congress to that effect, and to grant commissions to privateers in conformity with the laws. 13th, to celebrate covenants with the Apostolic Chair, as designated in Clause 12 of Article 50. 14th, to direct diplomatic negotiations, and to celebrate treaties of peace, amity, alliance, truce, federation, armed neutrality, commerce, and all others, but to give or deny the ratification of any of them requires the approbation of the General Congress. 15th, to receive ministers and other envoys from foreign nations. 16th, to request Congress to prorogue their sessions for 30 days, Sundays, and c. or etc. excepted. 17th, to assemble Congress for extraordinary sessions, as he may deem the case necessary, by the consent of 2/3 of the Council of Government present. 18th, also to assemble an extraordinary session of Congress, when the Council of Government shall deem it necessary, and the vote of 2/3 of the members present is given to that effect. 19th, to see that justice is promptly and impartially administered by the Supreme Courts, tribunals, and inferior courts of the Federation, and that their sentences be executed according to law. 20th, to suspend from their employment, for the space of 3 months, and deprive 1/2 of their pay, for the same time, all officers belonging to the Federation, violators of its orders and decrees, and should there be cause for a prosecution against such officers, he shall place the subject before its proper tribunal. 21st, to grant the passage, or retain the decrees of the ecclesiastical councils, pontificate bulls, briefs, and rescripts, with the consent of the General Congress, if they contain general dispositions, to be laid before the Senate, or in its recess, before the Council of Government, if containing governmental business, and before the Supreme Court of Justice, if it is a subject of litigation.